So I am so happy to have Amir Ali here to speak with us. He's the executive director of the MacArthur Justice Center. You have his bio in your agenda, but just a couple things I wanted to highlight. First of all, the last line of your bio, which I think is so interesting, is that your brief opposing President Trump's Muslim ban was cited by Justice Sonia Sotomayor in her historic dissent. So congratulations on that.
Thank you. I wish it was the majority, but you know.
It was the majority, yeah. So the other thing is the mission of the organization is to, create a cutting-edge litigation to create a more just and humane legal system. Obviously, this is probably the most contentious of the many institutions. This may be the most contentious institution that you'll be called on to cover next year. So I'm going to just turn it over to Ali to talk about some of the issues, how to cover the court, and we're going to leave lots and lots of time for questions. And thank you for being here.
Thank you so much. Thank you for having me. It's really a pleasure. I was told that you are all the stars in the future of journalism in DC and around the country. So quite an honor to speak with you. I'm going to give you a little bit of background to just contextualize my own speaking and maybe priors coming into this. The first thing I'll share is that I most frequently am arguing in courts of appeals across the country, including the Supreme Court. And so what that means is I'm used to speaking in front of judges, and usually groups of judges. In the courts of appeals, that's 3, all the way up to 9 in the Supreme Court. And sometimes, rarely, a court of appeals will get together all of their judges to hear a really important issue. So recently I argued a case, it was a police violence case, in front of 18 judges of the Fifth Circuit in New Orleans, Louisiana, which is about the size of oh, okay, we got someone from there, about the size of this group. And the reason I share that is that I don't know if any of you have ever seen an argument in federal court or state courts for that matter, but judges typically just interrupt you whenever they want to ask a question. And today I was asked to talk for 10 or 15 minutes without interruption, which I'm very uncomfortable with. I'm used to people just interrupting me whenever they want. So I'll be eager to get to the question and answer and talk about what you all are most interested in. The second thing I'll offer you is that I'm here to talk a little bit about the Supreme Court. I think a lot about the Supreme Court, but I'm actually quite hesitant to refer to myself as a Supreme Court lawyer. And there's a few reasons for that, but first and foremost, I litigate cases for typically 3 types of clients. My clients are either people who are in court trying to hold police officers or correctional officials accountable for some sort of misconduct. I represent people who are incarcerated, who are in court trying to raise some sort of oppressive or violent thing that's happened to them behind bars. And then I sometimes represent people who are accused of crimes, criminal defendants. And all 3 of those classes of people tend to do pretty poorly in the Supreme Court and in our federal court system today. So I actually spend far more of my time today trying to keep cases out of the Supreme Court than trying to get cases into the Supreme Court, which isn't that common among people who are, Supreme Court lawyers. So I thought about how to structure the discussion today, and I thought I'd offer you kind of a discussion that goes through each of the phases of a case before the Supreme Court. So I'm going to start with talking about how the court decides what cases it will hear, whether it will hear a case or not. I'm going to talk about when it does hear a case, the oral argument, and how it considers the merits as a case, as the lawyers put it. And then we can talk about decisions of the court, the judicial opinions of the court. And I thought for each of those categories, I try to offer you, my perspective, how a lawyer is thinking about a case, in case any of you in covering a case, want to understand what might be going through the lawyer's mind. And then also probably spend more time, giving you some thoughts on what I think is missing from the coverage of the Supreme Court at each of these phases. Okay, so first, I want to talk about this, and I start here not just because it's the first chronologically before the court, but I also think it's probably the phase that gets the least amount of coverage that probably deserves the most amount of coverage because it tells you a lot about the Supreme Court as an institution. Let me give you a little bit of background on this phase, which lawyers call the petition for certiorari phase because they love Latin phrases, and that's what the Supreme Court refers to it as. This is what it's referring to, by the way. This is a petition for certiorari. This is a book. It's not always filed as a book, but this is a book that gets filed in the Supreme Court, and what it's asking the Supreme Court to do is take a case, to hear at least one, sometimes more than one issues. This particular one was asking the court to hear two separate issues. Does anyone have an idea of how many petitions for certiorari the Supreme Court gets in a given term, given year? Oh, what was it? What was the number they gave you? Yeah, it's actually more like 7,000 to 8,000 a court. Who told you that? Was it someone at the Supreme Court? Yeah, okay, 5 to 7. The Supreme Court's website today still says 7,000 to 8,000. There are different ways to count it depending on what you kind of bring into the definition of petition for certiorari. But looking at about like 5,000 to 8,000 petitions, 8 if you include all of the people who are incarcerated, who are not filing these booklets, but filing papers asking to get their cases reviewed. And they maybe told you this as well. I won't ask it as a question because you guys have cheated and went directly to the court to get answers. But the court grants less than 80 cases a term. I think last term they issued decisions in something like 66. The term before it was 67. And so there's a huge winnowing that happens at this stage, right? 8,000 to, let's just say 80 to be generous to the court. Although it's been some time since they've even decided 80 cases. You're looking at about a 1% success rate if you're a lawyer before that phase. And, I think there's kind of two reasons that has a lot of meaning, or two takeaways from that. First, the justices have to figure out how to get from 8,000 to 80, right? And I'll let you in on a big secret. The justices have a sense of self-importance. Some might even say ego. Quite naturally, they want to spend their time working on the most important cases, and that's how they're going to think about it. And they might have different ways of defining that. There are kind of some standard things that lawyers turn to tell the court that their case is most important. But that's how I'm going to think about it as a lawyer. When I'm filing this docket, what I'm trying to tell the Supreme Court is my case is so important that it should be one of those 80 cases that you take. Now, the problem I have when I do that is that the other 8,000 petitions are also saying that, and the lawyers on those cases are also saying that. And I highlight that for you, both so you know what's going on at this phase from a lawyer's perspective. It also means that there's a kind of unique opportunity for media and for journalists and reporting at this particular stage, right? Because what a story on a case at this certiorari stage means is that there's been some independent validation, really, for a lawyer or for a party as to the importance of their case, right? There's going to be one of these filed in all 8,000 of the cases. There's going to be a story written about a handful of them, very few of them. And so, this is a stage, for instance, in which a lawyer is probably going to be willing to talk to you about their case and bring you into it. And that's because they actually have quite a bit to gain in having that, independent validation that some sort of journalism outlet has decided to write about the story in the case. The second reason I raise that, and the second takeaway, is that this shows you that there's actually an immense choice the Supreme Court has, right? 8,000 down to 80, right? In selecting what their docket will be. There's, minimum, again, of one issue in each petition, sometimes 3, 4, 5. And so there's actually tremendous choice that the justices have in deciding what issues they will issue opinions on. And I'm going to come back to that in a second. One of the things I want to drive home about this phase is that each of these 8,000 petitions involve real people, real issues, and real stories. I'm going to give you an example of a client of mine named Corey Williams, and I'm actually just going to read you. This is the petition we filed on behalf of Corey, just the very beginning of the petition we filed for him, and tell you a little bit about how the case unfolded to show you how significant and what an opportunity there is for telling stories about what's going on at this phase before the Supreme Court. So the petition begins, in January of 1998, Corey Dwayne Williams was an intellectually disabled 16-year-old child. He still sucked his thumb, urinated himself on an ordinary basis, and regularly ate dirt and paper. Throughout his childhood, he was hospitalized for extreme lead poisoning, institutionalized multiple times, and placed in special education. The petition goes on to tell the story of what happened to Corey. Corey was out late at night in Shreveport, Louisiana, because he was known to be impressionable. Some people who had committed a horrific crime, who had murdered someone on the street, pinned the crime on Corey. He ended up being convicted of capital murder. He spent 20 years at Angola Penitentiary. The first part of that was on death row. He was eventually taken off of death row, both because he was intellectually disabled. There's a Supreme Court decision saying you cannot execute someone who's intellectually disabled, and also because he was a minor. There was a Supreme Court decision after he was convicted that said you cannot execute someone who was a minor when they committed their crime. So he was kind of the double whammy of someone who shouldn't be there. He also shouldn't have ever been there because he was innocent. He didn't have anything to do with the crime. And in fact, the issue we raised in our petition had to do with the suppression of evidence that exculpated Corey. What had happened is that police officers had reported to the scene on the day of. They had interviewed several witnesses, and some of those witnesses specifically said, we had seen what happened. It makes no sense to say that Corey Williams committed this crime. He literally had nothing to do with it. And those interviews were suppressed. They were never shared with the defense despite the constitutional obligation to do so. Now, the state of Louisiana defended Corey's conviction nonetheless for 20 years. Again, he spent in prison. And it was when we filed this petition in the Supreme Court telling Corey's case that the DA for the first time in 20 years came to the table willing to talk about what to do about Corey, willing to talk about his release. And within a week of them coming to the table, Corey walked out of prison. And so, there, within this pile of 8,000 petitions, which, could fill this room, really, there are real stories to be told and real injustices. And a real opportunity, I think, for journalists to dig in and tell those stories. So the other thing I want to do is come back to the point I made a moment ago. 8,000 to about 80, right, is kind of the winnowing that happens. Yet, one thing I find when I read coverage of the court is that it's not covered in that way. Right? Typically, coverage of a Supreme Court case starts when the court grants a case, right? So what we see is the alert that comes on our phone. Supreme Court decides to hear, this issue, the issue of abortion in Dobbs. Supreme Court decides to hear affirmative action, which is on, before the court this term. And then the coverage tells you about maybe the story in that particular case, the arguments on both sides, and what the court's going to decide. The question that I don't see often asked to relevant stakeholders who would be willing to comment on this is why, right? The court had 8,000 petitions. Why did it take up this issue? Why did the court take up affirmative action this term, right? Out of those 8,000. It's an interesting question because the affirmative action decisions were applying settled precedent that existed. One of the things the Supreme Court, I'm not going to get into all the details, but one of the things the Supreme Court looks for in whether to grant a case is whether there's been this confusion among lower courts, right? And that's one of the things that it views its role as settling disputes among the lower court system so that we have uniform laws. Well, there was no, confusion when it came to affirmative action. It was settled precedent that was being applied, yet the Supreme Court decided to pluck that out of two cases out of the 88,000 cases. Or petitions that it had in front of it. So that's one question that I see often overlooked at this stage. Okay, so now we can talk about what everybody actually always wants to talk about, which is the cases that the court actually decides to hear. It's lawyers, we talk about this as the merits phase of the Supreme Court, which includes both briefs, which again, people generally don't want to focus on the briefs. They want to focus on the glamorous oral argument before the justices. Ironically, this is the stage when a lawyer involved in a case before the court is least interested in talking to journalists. More likely, at least this is how I approach it, I want anything I say at this point to be in front of the justices and to the justices and to have control of the message. And so if you're covering a case at this stage, you can try to talk to the lawyers. They'll probably be reluctant to say anything to you, at least on the record. But you'll have to think about where else you look to tell the story and capture what's going on in a case. And I'm going to focus on this issue where journalists tend to like to focus the most, which is at the oral argument phase. That's when, in the cases I've litigated, and generally speaking, when we can assume there's going to be attention from the media on the case. And I'll share a couple of thoughts with you on how to think about oral argument and maybe some pitfalls or things that are overlooked. The first point I'll share is that if you watch an oral argument, there's a lot of back and forth. But it doesn't necessarily mean that the justices and the lawyer are talking about what's actually going on in a case or what's actually at stake in a case. I'll give you an example, my own example, from a case I argued last October that was decided by the Supreme Court last term. It was a case called Thompson v. Clark. And I'm not going to get into all the details about the case. I'm happy to talk about it more if folks are interested. But it was a police misconduct case. And in my view, the case was about racist policing. The case was about a phenomena called cover charges, which is a practice when police officers, having engaged in their own misconduct, say arbitrarily searching someone on the street without justification or using violence against someone without justification, later seeks to kind of justify that or cover it up by saying that the person that they searched or the person they used force against was the aggressor. So often the most common charges we see here are resisting arrest, often begging the question of why you were arresting them in the first place because there's no other charge to accompany the resisting arrest, or obstructing justice, sometimes assaulting an officer. Those are kind of the three, which, by the way, police departments themselves that are trying to identify bad officers actually search for officers that are charging these things at disproportionate rates. And so it's a phenomenon that's well known even within the law enforcement community. Now, I say all that to say, if you watched my oral argument in Thompson v. Clark, I never mentioned racist policing. I never mentioned cover charges once. I argued the case based on neutral legal principles and history. And so if you just looked at the oral argument, the back and forth between me and the justices, you would have had no idea that that's at least what I thought was mostly at stake. Now, in this case, we actually did bring that into the case. More specifically, we had friend of the court briefs, amici briefs filed in the case that discussed that particular angle of the case, multiple that talked about kind of the structural racism and the issue of cover charges and the prevalence of cover charges. We actually thought that was strategically advantageous for the court to know that that's in the background here, even if it wasn't what I thought would be persuading the justices in the live oral argument. So I say that to say you might actually need to kind of pierce the veil a little bit to understand what the cases are actually about. I'm going to come back to that in a minute. The second thing I'd offer is that covering the court, and particularly covering oral argument, requires some real attention and care as to the dynamics of oral argument, because it's not always super intuitive. So the Thompson v. Clark argument I just mentioned to you that I argued last October, if you watched that oral argument, you would have seen me getting beat up over and over again for 40 minutes, basically. And I was kind of getting exhausted with having to kind of answer these questions on a very defensive stance in the case. If you watched that and weren't careful, you probably would think that we were going to lose the case. And despite feeling, exhausted by the end of the 40-minute period when they kept me up there, I actually sat down feeling quite comfortable with where we were in the case, thinking we were going to win the case. And that helped. I had a co-counsel who, as soon as I sat down, she whispered to me, basically the only justices who seem to be against us have the last names Thomas, Alito, and Gorsuch. And so while it was, quite a difficult argument, by reading where the justices seemed to be, and in some ways paying attention to the justices who were silent, or who asked, only small questions, that's where we could figure out where most of the justices were. And sure enough, when we got the opinion in the case, there were 3 dissenters with the last names I just mentioned, and the rest, came along with us. So, it can be a little bit deceiving to someone who's not really trying to pay attention to who's asking the questions and who's not asking the questions, and where the justices are. The other piece of this is that oral argument is a multifaceted conversation, right? So it both from lawyer to justice and also from justices to justices. And so when I answer a question, a hostile question or any question, I'm always trying to answer the question that I'm being asked, but I'm also mindful that there are 8 others who are listening, and that my votes may actually be more likely to come from those 8 others than anyone who I'm speaking to, which impacts how you're going to answer the question, right? I can't totally dodge it, but I might be answering a question that I know is going to be completely unsatisfactory to the person I'm speaking to, simply because I don't want to give up the other people who are listening to the case. It's also multifaceted justice to justice. Oral argument is often the first time that the justices themselves kind of discuss a case together by practice. And so often what you're seeing at oral argument is justices kind of, by asking questions to the attorney, floating ideas to their colleagues. So they might have a theory of how to resolve a case, maybe one that neither attorney who's in front of them has offered or would like, and they're going to ask a question about it. And they actually might not care all that much about what I have to say about it or what the attorney has to say about it, but they will care about whether when any of their other colleagues jumps in on the point or kind of like rolls their eyes at the point. And so there's a lot going on at oral argument that's worth kind of taking into account, getting perspective on from experienced court watchers if you are covering a case at this stage. Okay, why don't we turn to the actual judicial opinions of the Supreme Court. Okay, so Supreme Court decisions, they get the final word, right? No, if there's one thing I could drive home to this room is maybe for lawyers that's true, but particularly in this moment, and generally, but particularly in this moment, I think journalists covering the court need to stop treating the court like the opinions are some sort of final word. And I do think that's the practice that I see in covering the court most often. And I'll develop that a little bit and offer what I think about it. But I do think, in my lifetime, we've taken for granted in some ways that the Supreme Court is this institution that's kind of beyond reproach. It's been a popular, there's been a lot of confidence in the court historically as one of the government branches. Obviously, that's not the case today. It's much lower than it has historically been in terms of public confidence. And I think we're just starting to see this really remarkable and in some ways groundbreaking coverage of the court that's no longer treating it that way. I'll give you an example, and then I'm going to bring it back to the decisions. But the Washington Post recently had what I think is truly groundbreaking, really hard work in a piece that covered the lack of diversity in front of the Supreme Court among advocates in the Supreme Court. And they found that 80% of the people arguing before the justices are white, 80% of the people arguing before the justices are men. And that sort of data had never been really collected before. And as I understand it by the article, they reached out to hundreds of lawyers who had argued before the court, asking them this information, and did a ton of independent research. And what's starting to happen is people are starting to understand that the Supreme Court is an institution of people who are imperfect. And it's an institution that we should be critical of, right? There's something actually quite wrong with the idea of an institution that is deciding issues, many of which disproportionately impact minority communities and people of color, but it's just time and time again, white man, justices, white man, talking about, again, remember what I said, neutral legal principles, to decide these cases that actually have huge stakes for communities. And so I think the more we can start to look and be critical of the court as an institution, and there's a lot to be written about that and beyond just the piece I mentioned. So let me bring that back to the actual judicial opinions, the substance of the opinions of the court. Because I think that sort of check needs to be there too, especially today. So the Supreme Court recently has taken a really sharp turn towards relying on history, to a degree that I think the court has never done in its entire history, to say that the rights that we have today are going to be decided based on whether those rights existed at the time the framers wrote the particular constitutional provision, although they can't really figure out what time they're supposed to look at. Now that's a question of fact, right? That's the work of historians not lawyers typically, and the justices themselves are not historians. And so what I typically see in covering the court is, here's the story, maybe. Here's the story of the client that gave rise to the case. Here's the dispute. Here are the arguments on both sides. And then we get the decision from the court, and it's like, here's how the Supreme Court decided the case. And that's how coverage of the court typically happens. I think we need more than that, especially insofar as the court's decision is saying, here is what history is. Again, a group of non-historians saying, here is what history is. I think if you were covering any other issue and someone made a factual statement to you about what history is, and that person didn't seem like an expert on what history is, you would say, maybe I should reach out to an expert on that. And I think that's the sort of way we need to cover this court, because by their own terms, they're saying they're going to decide what rights we have, what the government can do, for instance, in regulating guns based on historical fact, some sense of what history was at the time. Go to the next slide. I think fortunately, and maybe like fortuitously is the better word, there's a model for this now in coverage of the court recently. And I think that model, the reason I say fortuitously, came with the leaked opinion last term in the abortion case. When that was leaked, the media, journalists, reporters had to treat it as non-final, right? Because it was formally not the final opinion of the court. And what you saw, not enough, not as much as I think there should have been, but during that period between the non-final leaked opinion and the opinion we got, was coverage that actually dove into the history that was being cited by the court. Is this accurate? And they went to historians and said, is this actual history? And that period, I think, is actually a great model for what I think we should do for all Supreme Court opinions, including the ones that are formally, the final decision of the court, is that I think when the media is covered, as a lawyer, I have to treat it as final, right? When I go into court, I can't just say, ignore what the Supreme Court said because they're wrong. I have to treat it as precedent. But you all don't and shouldn't. I think that you all should treat it as one viewpoint, especially when we're talking about fact and history out there in the world. And in fact, there may be people who are experts and trained in that area who disagree with what's being said in these opinions. So I put this up, some of the headlines that followed the leaked Dobbs opinion is kind of an example for that. And I think this idea of treating the court as non-final from the perspective of covering it is really important. And I'll give you one other takeaway also fortuitously from the leaked Dobbs opinion that I'd love to see in the coverage of all Supreme Court opinions. And that's one other thing that journalists did in response to Dobbs, which was actually try to go beyond the case itself in terms of contextualizing the real world impacts of the case for other people, right? For all of the different ways in which different communities were going to be affected by Dobbs. That's something, again, that doesn't tend to happen in the coverage of the court. It's like, here's this dispute between these two parties. Here's what the Supreme Court said. It might have this consequence for that party. But there isn't that extra step of, we've actually figured out the other stories out there, the other people's lives who are going to be impacted by the case. And I'd love to see and think it's really important that that become a piece of covering the court's decisions. That's all I've got. I'm gonna leave you with just one quote that has particular significance to lawyers that shouldn't have significance to you, which is the Justice Robert Jackson, who's famous for being a Supreme Court justice, but also for having prosecuted Nazis at Nuremberg while he was on leave as a Supreme Court justice. In an opinion, concurring opinion for the court, said, I'm paraphrasing here just to make it easier to say, the Supreme Court is not final because it's infallible. The Supreme Court is infallible because it is final. Now that makes a lot of sense to lawyers. Like I said, a lawyer has to treat the Supreme Court as infallible when you walk into court because it happens to be the final decider of issues. But it really shouldn't be the way, I think, that journalists and reporters are covering the court. I think they really should treat it as an institution that is fallible. So with that, I'm very happy to answer any questions you all have.
Hello. I'm Candace. I work for the 19th, and I have two kind of very different questions. First is in relation to the diversity of the Supreme Court advocates that you talked about. What is like the pipeline? Like, how does that work? Like, because there's a Supreme Court bar, right? I'm just curious. I mean, I'm sure there's a lot involved, but I'm curious what that like pipeline is like, because it seems like a lot of the people who are arguing before the court also do it like multiple times.
Yeah.
So, yeah, so I don't know if I should stop there and then ask my next question or
Sure.
what.
I'll let
Okay.
you ask another one too. But yeah, why don't I try my hand at
Yeah.
that one?
Okay.
So I think about this issue a lot, and it's often framed in terms of a pipeline problem among people within the Supreme Court bar. I don't think it's a pipeline problem. I think there's pretty clear evidence that it's not a pipeline problem. Um, and to me, the clearest evidence is that if you go behind the often white man who's at the podium arguing the case and look at the names on the briefs, it's often women and people of color who are the lead authors of the briefs before the court. Now, so there's plenty of people who are literally just, seated next to or behind or whatever, who are ready to stand up and do the work, and who are importantly experts on the court, right? They're writing the briefs because they're experts on the court, and the person sitting at the podium trusts them to be an expert on the court. And so this isn't a matter of, sidelining expertise in order to have someone with a different background step at the podium. Now, what it is a matter of, I think you referenced, the fact that we call it the Supreme Court bar. Just to be very clear, the formal Supreme Court bar, to be admitted and to stand up at the podium at the Supreme Court, requires almost nothing. You have to be 3 years out of law school and get two people to sign something for you. So that's the formal Supreme Court bar. The kind of functional, practical Supreme Court bar, the kind of exclusive club that I think about when people use that term, is built around this idea of there are certain people who have done this the most. And if you are a client whose case ends up before the Supreme Court, what you should do is go seek out the person who's argued the most times in front of the justice, which of course is a perpetuating cycle, right? Because the people who have argued the most are the same white men. Now, I think that's actually kind of foolish in a lot of cases, because I think that prioritizes to an extreme degree one kind of expertise, which is, expertise on the court, when there are other kinds of expertise that really matter, like life experience in a case. And so I always think back, I was quoted on this in the Washington Post article I mentioned, but I think back to the Brown v. Board arguments, Thurgood Marshall arguing that case, and I think it was more than symbolic that it was him arguing that case. And there's this moment in his rebuttal, his final time standing up before the Supreme Court in this case, where he decides to end not on neutral legal principles, not on, law or history. And he says, I want you all to picture right now kids in the South, white and black, walking together to school. And he pauses and he says, and I have seen them do it, right? That's him inserting his life experience in a way that's another advocate wouldn't be able to do. I've seen them do it. They walk, laughing, playing until they get to a certain point when they have to part ways. And then they exit school, come back and join and continue walking, laughing, and playing. And I think it's just a perfect example of how, there is a different type of expertise here, which is life experience. And if you prioritize one and not the other, one, it could affect kind of the legitimacy of the whole enterprise, right? If there are people or perspectives that are being excluded from the courtroom. But two, you might actually get worse advocacy if you don't have a lawyer who can make that point and who actually truly understands the stakes and equities of what's going on. Now, that's not going to be the case maybe in every case. If it's Corporation A versus Corporation B, maybe that doesn't apply as much. But like I said, there are a number of cases that go before the court every term that impact particular communities. You had a second question, Candace.
Yeah. I was trying to think about how to word this. Okay, so a lot of people feel like they don't, the public, members of the public don't have the same sort of say over the Supreme Court like they do, like even the president or members of Congress, et cetera, in terms of voting. I mean, obviously, depending on who you vote for as we elect as president, that determines stuff on the Supreme Court. But like, it's not a lot of turnover generally. And I guess I'm curious, like, from an accountability standpoint, I'm trying to like, what do you see as like the accountability value of like journalism on this institution? Like, I see the value of like a story post Dobbs decision where you're looking at kind of how this policy is impacting like everyday people. But in terms of like holding the institution accountable, do you see journalism being able to do that in the same way? Does that make sense?
It does make sense. Yeah. Yeah. I think you're right. I mean, the branch has been designed kind of deliberately in a way that is unaccountable, right, to the political branches. And that's the reason for life tenure of federal judges and Supreme Court justices. They're unaccountable actually in the Supreme Court in a more extreme way because even ethical rules don't apply to the court. And so, you know, if the question is, do I see value in it? Absolutely, because where else is the accountability going to come from? It's not clear to me other than public discourse about, say, potential ethical violations of the justices. Where will the pressure come from? Now, ideally, you have a court that's kind of just driven by, each justice is driven by their own principle and adherence to ethical values, even though they don't have to. But you can see, I think, pretty clearly how that seems to have shifted. With things that are going on, for instance, with Ginny Thomas and just, no recusal in cases that seem connected to things that she might have done. Going all the way, by the way, back to like Bush v. Gore, where Ginny Thomas was quite literally, hired and being paid to be part of the transition team and decide who would serve in the Bush administration, while, Clarence Thomas was sitting on the Supreme Court and making the decision as to whether that person would be president so that that work would be relevant. The only place that discussion can take place and where there can be some light shed on and accountability, I think, is in the public sphere. And we might just continue to shift in the direction unless there's more of that.
Yeah. Sorry. Yeah. I didn't mean like value of like reporting on those issues, but I guess whether they hold the same kind of like weight, as opposed to a bombshell story that could result in a particular lawmaker like getting voted out or something. We could report on something, but that doesn't necessarily, if Thomas doubles down on like not changing or not recusing himself from particular cases or whatever, I feel like it maybe doesn't have the same effect, but maybe that's just me.
In terms of prioritizing which one of those two things you would spend your time on?
No, I don't know. I was just trying to figure out, like, if we're reporting on this issue in terms of conflicts of interest, if a justice decides that they're not going to change their behavior, it's not the same kind of accountability factor there as like maybe a lawmaker who has to consider whether they'll be reelected in the next, cycle.
Yeah, I think that's right. I think it's a taller task to get them to pay attention, in part because the structure is set up so that they don't have to pay attention in a lot of ways. But I do think historically public opinion has mattered a lot for the court, maybe matters less for the current Supreme Court. But I think that it has mattered. I do think the justices are people and care about their reputation. Again, it might depend on the individual justice how much and how they care about their reputation, but I think they do. And so for that reason, it's important. I think it also happens to be important just as a matter of principle that these things be discussed too. I'll just mention one other thing, which is that, like, if there are going to be ethics rules passed that apply to the Supreme Court, it might come from the legislature too. And so that's another reason. It's not that there can't possibly be any accountability for the justices.
Hi, my name's Ryan. Thanks for doing this. I was wondering, you mentioned the idea that the things at the Supreme Court, I guess, aren't final, or the idea that there's some movement there. Could you kind of explain more about what you mean? Do you mean that there are more legal tactics that stem from these things, and that these issues aren't final in the opinions that they release? Or are you talking more about the fallibility of the court as an institution, or overall? Or could you kind of talk more
Yeah,
about that
sure,
point?
sure. I was trying to make a distinction between, and maybe I was, half too clever, between how a lawyer would approach what the Supreme Court is doing and how I think journalists should think about what the Supreme Court is doing, particularly in this moment. So as a lawyer, the Supreme Court is final, right? What the Supreme Court says is going to govern all the cases in the lower courts. And you have to treat the Supreme Court as final, except a very small select group of people who are trying to overrule Supreme Court precedent and might not treat it as final. But as a lawyer, generally speaking, the Supreme Court is final in what it says. But in this particular moment, and I think generally, I think that it is important that when it comes to the substance and what the Supreme Court is saying, that coverage of the Supreme Court not treated as final. And I'm kind of contrasting what I see as the usual way of covering the court, which is, again, telling the story of what the case is based on, the arguments on both sides, and then we get an opinion. And what is often kind of journalists are prepared to do in that moment is say, here's what the Supreme Court said. That is the story. What the Supreme Court said is what we've been waiting on and what the story is. And I actually think that's just like the beginning of the story, right? The story is, okay, well, the Supreme Court decided that the Second Amendment protects the right to carry arms outside of the home, which was a decision from last term. But, it did it on the basis that that was a right that existed historically, which is a hotly disputed account, right? I mean, I'll use that one example, for instance. The Second Amendment landscape right now that was decided first in a case called Heller, and then McDonald, and then most recently in this case called Bruin that was decided last term. That theory of the Second Amendment that was adopted, the understanding of the Second Amendment as protecting an individual right to bear arms. If you go back 30 years, right, Chief Justice Warren Burger, who is a Republican appointee, conservative justice, after he retired, was asked about that theory of the Second Amendment. And he said, no one is advancing that other than the gun lobby. And he called it, quote, the greatest fraud on the American people, right? 30 years ago, conservative, Chief Justice of the Supreme Court who had retired, calling that theory the greatest fraud. Fast forward to Heller and to Bruin, where the Supreme Court is saying that is the history, right? Now, as a lawyer, I have to treat that as final. And I don't still really even know what that means, right? A Second Amendment lawyer has to live in this bizarro world where something is history, and the only way to make your case as to Second Amendment rights is to say, like, that was history even though it wasn't, and try to argue based on this strange, false history. Now, you all don't have to do that, right? And I think that kind of what I'm saying is, in this, at a minimum equal footing, the Supreme Court and historians you might consult. Again, that's just the beginning of the story, is what the Supreme Court said. But I think that an important piece of this is, what qualifications do they have to do that? Or if you don't even want to say that, what experts are there out there who can tell us something about the way that the court got to the decision? And when I say not treating it as final, I just mean, for your purposes, the story doesn't end there, it starts there.
If we're doing, so say journalists now, we start holding them more accountable on their history. Do you feel like that would shape, you said public opinion does weigh on the members of the court. Do you feel that an emphasis on actual historical experts by outside influences will shape their thinking, will adjust how the court responds to things? I mean, do you think there would be an outcome from that? I mean, regardless, there's obviously an imperative for journalists to do those types of stories anyway, but do you think that there would be an outcome if that kind of lens was treated to the Supreme Court more?
I guess for me, the most important piece of it is the kind of principle, right? I feel like you all are the journalists, so I won't tell you what your job is, but I feel like, my job as a lawyer is to argue and make a case on behalf of my client. I think like truth and facts is kind of your business, right? And so to the extent we have a government institution that is, writing full opinions about history that might actually be divorced from truth and fact, that's just the business I think you all should be in. And the same way, again, that if you were to talk to somebody who was saying something to you and you're like, I don't think you're an expert on that, and I don't think that's right, you would check them on it and consult the actual experts on it. I think it's important you all do it. Now, I'm not actually answering your question as to whether I think it's going to make a difference. I don't know. I mean, we'd have to kind of wait and see. I'll tell you this. I think that the justices are self-conscious about this point. So if you go to, maybe getting more in the weeds than you want to on this, but if you go into the Bruin decision, that's the Second Amendment case from last term, there's a footnote that Clarence Thomas drops on this point. He says, we've been getting criticized on this whole notion because we're not historians. I'm paraphrasing him. And the dissenting opinion by Justice Breyer accuses the court of the majority of law office history where they're cherry picking things. So it's not like they're not aware of this criticism. And what he says is, well, that's okay that we're not historians. We're not persuaded, is what he said by that comment, because we just decide cases based on the arguments that parties make in the case. Now, one, the fact that he dropped that footnote suggests to me that they're self-conscious about this point, right? There's a lot riding on this whole idea of we turn to history, and they say this in their opinions, both in Dobbs with the abortion case and in Bruin, the gun case. They say the reason we're doing that is because it lets us be super objective, right? They're not shy about that. So they're very much invested in this methodology and trying to prove it's right. Now, this explanation of it doesn't really matter because we just decide based on the party's arguments, like, isn't very satisfying, right? Like, if that's the best argument they have as to why they can get history wrong, like, that doesn't offer any comfort whatsoever, right? Like, these lawyers said it, those lawyers said it, and so now we get to decide history. And so the fact that they dropped that footnote suggests to me they're thinking about this and self-conscious about it. And the fact that they really didn't have much that I think anyone should take comfort in resolving it suggests to me that continuing to kind of hit this point might be worthwhile.
And then, not necessarily related, but you did mention kind of court watchers and how they can be helpful for journalists in terms of understanding what's going on in the arguments. This is kind of a staunch thing that people have covered the Supreme Court for a really long time. Where would you suggest that journalists kind of diversify who they're looking towards in terms of court watchers so that they can get a more full picture and not just use the same kind of talking heads that have always been used?
Yeah, that's a great question. I think that my sense is that typically journalists, it's going to be a very experienced Supreme Court advocate at the podium arguing the case, and that journalists often turn to some other very experienced Supreme Court advocate who doesn't happen to have a case, pending that day in the court or maybe pending it all in the court to comment on what's going on. I think that can be useful, again, because there's a lot of dynamics going on in the court. And so maybe if that's the point you're looking for is, what was happening in the courtroom, that might be who you turn to. Again, there's a deep bench, right? You don't have to go necessarily. Just look at the briefs that are, that have been filed in the Supreme Court. There's a very deep bench of people who you can consult who are experts. They're on those briefs because they're experts. I think that what I would suggest is that someone who's trying to actually capture the stakes of what's going on in a case and kind of what I was explaining, like what actually might be at issue in a case, that journalists covering the court go beyond the kind of Supreme Court bar. Most of the journalists covering the court know the Supreme Court bar well. I'll be at events and the journalists who cover the court will be at those events and there'll be, relationships built. But often, say, in a case involving the rights of a criminal defendant, if I'm involved in that case, the people who are going to be able to comment on what's actually at issue in that case aren't members of the Supreme Court bar. They don't know anything about criminal defense cases until they have a case before the Supreme Court, and then they become experts on it and argue. So they might give a comment. Are they going to truly capture what's at issue in that case? Probably not. Now, if you turn to criminal defense lawyers, public defenders in a case, even if you don't have a relationship with them, but try to identify people with actual substantive expertise. Again, they may not be experts on the Supreme Court. They may also be, but they may not be experts on the Supreme Court. But that's what I would encourage folks to do, is to turn to people who are more closely tied to the relevant issue.
Hey, are there cases you're working on now that you want to talk about? Like, are we in this period? I mean, I guess the calendar might already be set, but substantively, Like, do you want to plant some seeds here while you're with a group of journalists?
Wow, I didn't anticipate that opportunity. You know, I'm not going to do that. You know, in part because most of the cases I'm working on before the court, I'm actually trying to keep out of the court right now, not have go to the court.
That's a story too.
It's a story that I don't want to be told, right?
Is there a particular strategy for that, or?
Yeah, so when I say I'm trying to keep cases out of the Supreme Court, every time one of these is filed, a petition for certiorari is filed, there's also a brief saying to the Supreme Court, don't take this case. Just turn it down, have it be one of the, you know, almost 8,000 that get denied each term. And I'm doing a lot of that work right now. And because anytime a federal court of appeals or a state court on some sort of issue of federal law expands constitutional rights for the clients I represent or provides greater access to courts, there's actually a risk that the Supreme Court's going to take that case and create bad precedent. And one of the areas where I feel like I can offer my expertise, both kind of in the civil rights law and criminal defense law that I do, but also with an eye towards kind of what the Supreme Court looks for or doesn't want in a case, is to come in with an attorney who might not have a lot of experience with the Supreme Court and try to help them defeat certiorari, is what we call it, or defeat review. So I have a big practice that's, and our organization has a practice that's specifically focused on that. It's protecting basically decisions that we see as positive in the lower courts. We have Ryan, and then I think Rachel wanted to ask a question too, but go ahead, it's good.
Okay, I asked this question to our prior speaker, but are there any like technical books that you would recommend people read to get a sense of, you know, like how the court operates, kind of on a very particular procedural level, and then also any like history books about the court in general to get a wider view of their work and the personalities involved?
Ooh. So technical books about the court and its operations, I don't know that you need a book for it. I honestly think that probably the best resource is actually just, there's a blog called SCOTUS blog, which both offers some coverage of the cases that are being considered by the court. It's one actually outlet that actually does focus on all of the stages I mentioned to you, including really trying to identify the petitions before the court. But in addition to all of that, it has quite a bit of material on how the court operates. And I don't think you need a whole book on it. I think that would be a way to do it. The other thing is, I think that's a topic where people who practice before the Supreme Court would be very happy to talk to you about that. I'd be more than happy to, if any of you have questions about the court's operations. I can't think of a book. I mean, the book lawyers turn to is called Supreme Court Practice. Stern and Gressman are the original authors of it, and it's a treatise that's like this big and will answer any question you possibly have about the court's operations. But I don't know that really is worth your time. Supreme Court Practice, I think, is the name of it. It's the last names of the authors are Stern and Gressman. Jeffrey Toobin's The Nine was my first entree into understanding like some of the justices and how they think, and he tended to focus on, you know, Justice O'Connor, and I think it was written shortly after Justice Kagan was nominated to the court, so it gives you a sense of kind of some of their trajectory. And this is one of those, you know, kind of behind the scenes at the court, some drama in it type book. I haven't read the recent biographies of the justices. In part, you know, I get my own knowledge about the justices just from like really paying attention day to day to their opinions and what's going on in the arguments. So sorry, I'm not that helpful on that question.
Okay. Hi, I'm Rachel. I'm a stat, and I cover healthcare. But I thought, so I don't know how much like overlap there is, but just as kind of an example of a question that I have been grappling with, kind of an accountability in the Supreme Court, was some reporting around like the insular cases, and I was kind of surprised that the Biden administration was defending them or like kind of using these like longstanding precedents, and I guess to uphold the laws. So I'm just curious if you have any thoughts about kind of the accountability on kind of the administration side as to kind of what they choose to defend. Yeah,
that's a really great and deep and hard question. I have lots of criticisms of decisions that the administration and frankly, state and local governments have chosen, positions they've chosen to take in courts and in the Supreme Court. I think there's a real need for greater accountability. I think, focusing not just on the federal government and focusing on other governments is really important here, because we do see the insular cases are one example, but there's lots of examples of things that I think public would be really horrified by, positions that are taken by different levels of government. The federal government in particular before the Supreme Court is in a little bit of a tricky posture because of the current makeup of the Supreme Court, which has the kind of, to simplify it, 6-justice supermajority, and then a progressive administration. I think they're doing a valiant job trying to straddle that, but I'll give you an example of kind of the counterpoint. One, it's not entirely clear how much the justices care right now what the position of the federal government is in cases. And as a repeat player before the court, the Solicitor General has to think about their credibility from case to case to case. And I think it's fair to say that the justices have been pretty skeptical of the idea of the government coming in and conceding issues, especially when it's changing policy from a prior administration. And every time it's done that, it's been asked at oral, the Solicitor General or whoever's representing the United States has been asked specifically at oral argument about the switch in position. There was, and this is from the big cases, they were asked in affirmative action cases to compare their position to positions that had been taken in prior cases, to like the most, there was a habeas corpus case that was a very specific, complicated statutory issue argued last week where the Solicitor General switched its position, and it was really kind of pushed on that idea of changing its position. And so more is going into that calculus than just what position, Joe Biden would want or the Attorney General would want. There is kind of a back and forth with the court that's going on there. There was a case, I was involved in this case, the term before last, that involved the First Step Act, which was the criminal justice reform bill that was passed during the last administration. And in that case, it was not a change in position, but the federal government took a position and sided with the defendant, basically conceded error and gave up the lower court, right? That's what's going on, right? When the government comes in and says, we're going to take the side of, that doesn't necessarily maximize government power. Usually what they're doing is not only taking that side, but giving up a lower court who had kind of a faithfully applied precedent. The Supreme Court was extremely hostile to the government's position in that First Step Act case. And the reason is that the way they see it, seem to see it, and the way a lot of prior administrations have seen it is, if there's a reasonable argument that can be made, then the government should stand up and make it, even if they don't believe in it. And that seems to be the way the justices view this. And every time this federal government, the Solicitor General, does something other than that and suggests that either prior positions were unreasonable, the court doesn't seem to be very happy with it. At least the majority of justices don't seem to be very happy about it.
It seems like you mentioned, I think, Ginny Thomas earlier. Is this period now where it seems like some members of the court, or I guess the justices in general, as political figures, it seems like that's sort of been a sort of new, I guess I don't want to call it a new front in sort of coverage of the court as an entity and the justices as individuals, but I guess how would you encourage us to think about sort of that dynamic as we sort of cover politics and cover the court and how it operates? Or has that always been a feature, and it's just sort of more pronounced with these specific examples of particular justices in these particular episodes recently?
I don't know if this is answering your question. I'll try, though. It seems to me like it's not something that you have to specifically take into account in covering the court, and that in some ways it's the court itself that needs to see how political everything is seeming just when the facts are stated, right? I mean, I think that the lack of public confidence in the Supreme Court right now isn't because people covering the court have suddenly been saying they're a bunch of politicians, they're just political actors, this is all politics. It has actually been because time and time again, everything or a lot has just been dividing based on what would seem like political preferences of the judges based on the party who appointed them. And so, I think that the problem, a few terms ago, while Trump was still president, Chief Justice Roberts came out and said, like, we don't have Obama judges and Clinton judges and Bush judges and Trump judges, right? The problem with that is that it seems like that's actually what we have when you actually just state the facts of how the judges are reported, are coming down on different cases. So I don't know if that answers your question, but it seems to me like there's not a particular attention that needs to be given to that piece of it in covering news. I mean, I think it should be mentioned, and maybe commentary included on that in terms of consulting folks in terms of what seems to be going on. But it seems to me like that sort of damage is being done by the justices themselves, whether it be just how they're deciding cases or failing to recuse themselves in certain circumstances that seem to detract from confidence in the court as an institution. Does that answer your question?
I don't know that I had a specific question in mind, but I was just curious what you're going.
Yeah.
Is this a more recent phenomenon, or is this something that if you just go back in our country's history, this is sort of necessarily a new phenomenon or issue in terms of the way people are acting on the court and sort of what you said about how people come down on certain decisions of court. Has that been just a feature of the court as long as there's been a court, or is this sort of a break in the sort of precedent?
So I think there have been times in history where there's been a perceived leaning of the Supreme Court. I think in our kind of modern history, we really haven't had a court that didn't have a swing justice on major important issues, right? So, Anthony Kennedy for a long period of time was the swing justice on issues, and before that, Justice O'Connor was the swing justice on issues. So you had someone who was appointed from one party who kind of sat in this middle ground and was willing to hear arguments on both sides. And I think on top of that, one thing you had was that you couldn't just point to the party that had nominated the justice, right? Because there were also justices like Justice Stevens who, and Justice Souter, both of whom now would be identified, would have, towards the end of their career, would have been identified as part of the liberal side of the court, both of whom were nominated by Republican justices. You can't say that about the court today, right? I mean, the way that particularly the big political decisions are being decided are, 6-3 based on party affiliation. For a very short period there, we got to test out what it was like to have the Chief Justice as that swing justice, but he quickly became irrelevant with the passing of Justice Ginsburg and the nomination of Justice Barrett. And so it becomes harder to kind of have what we had been used to for decades.
It seems like that's sort of downstream of politics being so polarized. The types of people who are nominated. I mean, is that something that you've noticed as well or seen in terms of people who are put forward for federal courts? Is it just, are these nominees who are just less, I guess, for lack of a better term, swinging more independent-minded, judicial figures, and it's just sort of going on from this point? Are we just going to see, if it's a Democratic president, Democratic senator, we're going to see this kind of judge, and if it's a Republican, if it's Republicans, it's going to be this kind of judge? Is that just sort of running this argument?
Yeah, I don't know the answer to that. I mean, I think it's true of the justices that we saw put up on the court during the Trump administration, that they did seem to have kind of the same validators and background and adherence to these kind of, these principles that they wouldn't depart from. And in some ways, I think it's fair to say a direct reaction to the Justice Souter, Stevens, Anthony Kennedys of the world, right? We don't want one of those. I don't think we've really, I don't think we've seen that yet on, across multiple administrations and on the Democratic side so far. I mean, I remember when I was in law school and Justice Kagan was nominated to be on the Supreme Court. She was my dean. And I remember thinking, I don't know anything about what Elena Kagan thinks about issues, right? And to some degree, you know, she had really avoided any commentary on anything. And I was like, I don't, and I think that if you really believe in institutions and you believe in law and rule of law and fairness and having an open mind, like in an ideal world, that's a good thing, right? We don't want to just appoint judges, you know, because we know specifically what they're going to rule on cases. Whether, even though that wasn't that long ago, it's become a naive way to look at the world. I don't know. You all can tell me that.
I want to ask about dissents, and I feel like we, at least me, because I did a lot of our coverage on Justice Jackson's nomination and confirmation, and you hear a lot about the importance of dissents. Like, even though, you know, these three women will be in the like minority, so to speak, on opinions moving forward, the power of dissents to like maybe lay out a blueprint to shape policy in the future. And I guess I'm curious, from a journalistic standpoint, do you have opinions on coverage that you've seen of dissents? And do you have like thoughts on maybe how we could bring more value to coverage of that area?
That's a great question. So I have a couple of thoughts on coverage of the dissents, and then I also have a comment on the kind of additional change in the court based on Justice Jackson being there too. So I actually think that dissents are very frequently just left out of stories, first of all. Often they're just like not grappled with, particularly on like the day of the decision stories. And I do think they're a source of important information and tell you some of what's going on in a case. So they can be like, again, I think just a starting point in a lot of the big cases. I think they're extremely important, but there's still commentary that's taking place in the context of this world that's confined by the precedent. So I'll give you an example. If you go and read Justice Breyer's dissent in the Bruin case, which was the Second Amendment case from last term, he wasn't saying what I said to you a moment ago about the whole theory of going to history here, you know, and the theory that historically the Second Amendment meant an individual right to bear arms being completely bogus, and we all knew that was bogus. He actually accepted that premise as basically fact, and within this frankly bizarro history argued that, you know, it shouldn't have applied to New York's gun regulation in that particular case. So if you only read the dissent and the majority in that opinion, you would have missed, I think, a big part of what was going on there and what was kind of odd about the whole back and forth between the two of them. And that's because that point about history had been already established by precedent in the Heller decision. And so in order to have credibility with his colleagues and not just be seen as, you know, keep in mind that what was going on, that was released the day before the Dobbs opinion, right? So Justice Breyer couldn't write a dissent saying, overrule Heller, right? Because the dissent the next day was saying, we've got to stick to precedent, Roe, right? And so dissents are really important, but you still have to look at them, you know, and contextualize them with respect to kind of what's going on in the court. Does that make sense?
Yeah.
There can still be a much bigger story than what the dissent is able to offer, because they may have other considerations like precedent they're thinking about, other cases that are pending before the court, other issues that they're thinking about that someone covering the court wouldn't necessarily have to think about. I'll just say about Justice Jackson, you know, I'll be interested to see, she had her first dissenting opinion recently from a cert stage case. You know, we have already got to see her in the courtroom, and if you haven't listened to her, or, you know, ask questions in an oral argument, you should. I mean, she is there to be there and to be prepared. And, you know, I was mentioning before, like if you know, you're covering oral argument or talking about a case that's being argued before the court, the dynamics and trying to really understand the stakes of a case, I think so far she's shown that she's like the one who's going to be in the courtroom, her and Justice Kagan, and often kind of Justice Alito for the opposite perspective, who's really going to ask incisive questions that are going right to the heart of a case. And I think she seems to be doing that regardless of whether she thinks it's a case that's going to go the right way or the wrong way. She's just putting the stakes on the table in really clear and crisp ways. So I'd encourage you all to listen to her.
How do you prepare for to make your oral arguments in front of the court? And like, are you holding mock oral arguments? Are you shaping your arguments about what types of questions you think the justices are going to ask, or based on their different personalities?
Yeah, I think it's a pretty, and I can answer for most people who are arguing before the court what they would go through, and what I do. I will do what we call moot arguments, where I try to gather a panel of really smart people to read my briefs in the case, read the other side's briefs in the case, and ask me questions that they think the justices would ask. And I'll do it typically 2 at least of those before I, argue a case in the Supreme Court, sometimes more, depending on how those are going and how comfortable I feel that I've covered the scope of the questions. And like kind of the implication of that is that what's actually going on in the courtroom when you're watching, it seems like this very organic conversation between lawyer and justices. Odds are the lawyer has heard every one of the questions that's being answered, and you ask kind of what I'm trying to do as I prepare. What I'm trying to figure out is what should be the thing that comes out of my mouth first in response to a question, which might be a very hostile question that's going to kind of keep 5 justices with me at all times, or persuade a justice that might not be with me at all times. And so that's why it's helpful to get a lot of minds in the room, to have someone come in and say, hey, when you said this, that actually worked. When you said this other thing, be careful, because it actually may put off some justices. I tend to go through that experience not like zeroing in on like the psyches of different justices, in part because for the issues I litigate, it can be really depressing to start thinking about the predispositions of different justices. But that's obviously in the background sometimes.